Okay, welcome to the Rains Feldman Cyber Liability Update. The usual suspects are here, and this week I want to talk about a situation that I see popping up a lot, and it has to do with rights of publicity. Now, we're used to lawsuits by famous actors and actresses against companies that might use their image to promote a product without securing their permission, and celebrities that get paid millions of dollars, I mean, are really damaged by that. I mean, those would be million-dollar claims. But what we see a lot, and I think it really afflicts a certain industry, and that would be I've had several cases in the plastic surgery industry, for example. So doctors like to take pictures of their work and show it to people, and that's how people decide how to retain a doctor or a plastic surgeon. And what happens sometimes is either the proper permissions aren't secured, or permission is given and then it's withdrawn by the patient, or permission was given 30 years ago before internet usage became commonplace. And so I guess I'll throw it out to you guys. I mean, I think technically people in that situation, let's say you have a patient who didn't give permission or revoked permission, I mean, they may have a claim in California, the civil code statute is 3344, but you don't have to be George Clooney to have that type of claim. Would you guys agree with that in this plastic surgeon scenario, or is there a counter to that?
No, I agree with it.
Well, I mean, the only one counter I can think of is, so the right of publicity is protecting someone from using your name or likeness as an endorsement of their service. So the question is whether putting up a before and after picture is an endorsement of the service, or if it's just a literal statement of fact saying, this person, this is what they look like before, and they look like this afterwards. And whether or not you think that's good is up to you to decide. They're not saying their service is great, it's a literal factual representation of this is what the service did.
Now, going off on a little bit of a tangent, would this invoke any of the healthcare privacy laws, do you guys think? I happen to not think so, because it's just an image of a procedure, but would there be HIPAA concerns, or the California version of that? I think the acronym is CMIA. Any thoughts on that? Well, I mean, I really haven't thought it through, but
I can see issues there where, plastic surgery is a little bit different. Just the fact that you've gone from this to this, but the fact if you're, I don't think it'd be realistic, but if someone goes in for a treatment for a disease or something, and you post his picture up and for your medication or whatever, you are revealing the person is on this medication or using certain services or has a certain disease. I'm picturing like like a STD medication that they just throw someone up there as one of their patients, and I think that would maybe have some HIPAA issues, or just.
I could see in that scenario. I can't really see it in the case of permission is given and then it's revoked or withdrawn, because that the patient would have let it out of the bag there. I guess what I'd like to
the only on that point, just on the other thing on whether permission is revoked, under the right of publicity situation, I don't see how a person could revoke their permission to use something like that. I mean, you have an agreement, maybe you cancel it and sue for damages, but that doesn't make sense. In the medical privacy context, I could see there might be a statutory right to revoke permission to share private medical information, like the fact that you've undergone a procedure.
Well, I think once it becomes that public, if there's already been a commercial or a billboard where they did it under right.
Yeah, it might no longer be private. You're right.
Now, we should talk about why, the obvious, issue, I think, with most of these cases is a almost complete and utter lack of damages. And for that reason, with the rank and file civilians, the statute provides for a baseline statutory damage of $750. Now, if the actual damages are greater, that's what you're entitled to. But the reason why a lot of these cases get brought is because there's an attorney's fees provision in the statute if you prevail. So those are things to keep in mind. If you're a doctor, you want to make sure you have your permissions documented. You want to make sure your IT people understand what images to use and what they can't. Otherwise, you could be subjected to one of these lawsuits. So that's all the time we have for the Rains-Feldman Cyber Liability Update this week. We will see you next time.